Ripple XRP magic piece that was missing for XRP to win case against SEC? We'll find out soon if Hinman's documents will be made public. However, the community may be disappointed because they may not be so important and interesting. Welcome to the Finance Up channel. Please watch this video to the end, like it, and subscribe to the channel so as not to miss the release of new videos. Also in this video, we will show the lucky winner of giveaway free 500 XRP, and maybe it will be you. So watch the video carefully until the end. The Securities and Exchange Commission, SEC, continues to slug it out with Ripple in the more than 2 years old case. In its latest filing, the regulator has opposed Ripple's motion to seal several categories of documents filed in connection with cross motions for summary judgment. The SEC states in the giant 9 partial opposition that many documents Ripple proposes to redact from public scrutiny are too essential. The documents will play a key role in summary judgment and hence cannot overcome the presumption of public access, the SEC noted. The SEC has filed its response in partial opposition to the Ripple defendants' motion to seal certain documents filed in connection with the parties' cross motions for summary judgment. The SEC highlights 5 categories of documents out of the 11 Ripple proposed to redact as having this importance. The first category is Ripple's proposal to redact documents related to its financial information. The securities watchdog explains that it is opposed to Ripple sealing the entirety of its financial records. The SEC notes that financial records from 2013 to 2020 are at the heart of the case and therefore require public disclosure. The SEC adds that these records will also not harm Ripple's market competitiveness. The SEC's arguments follow a similar path in making a case for unsealing the other 4 categories of Ripple documents. These include Ripple's contract terms, the identity of third parties, compensation information, and individual defendants' personal and financial information. On the same day, Ripple also filed its opposition to the SEC's motion to seal certain documents connected to cross motions for summary judgment. The fintech giant points out that the court recognizes that the presumption of public access to judicial documents is currently at its strongest. The Ripple defendants XRP have filed their response in opposition to the SEC's motion to seal certain documents filed in connection with the parties' cross motions for summary judgment. Hence, it urges the court to deny the SEC's motion to seal emails related to Bill Hinman's speech. This is because the SEC uses parts of the document in its arguments for summary judgment. The document is of high public interest in the case. Ripple also notes the defendants further requested that the court reject the SEC's request to seal their experts' names and identifying information. Ripple argued that the SEC has failed to differentiate between the circumstances of each expert. Similarly, 3 of the experts are already publicly known through their disclosure. Whether or not the court ultimately determines those documents are relevant is beside the point. They are part of the summary judgment record, and there is no compelling basis to keep them sealed. The SEC's motion should be denied, the filing said. Stuart Alderoty, general counsel at Ripple, recently highlighted the part played by the SEC in the recent crypto contagion triggered by the FTX implosion. According to him, Congress should examine the financial regulators' policies that might have contributed to the contagion. Alderoty believes some of these policies were beyond the SEC's jurisdiction. He made these remarks in a recent article published on Fortune magazine. Alderoty noted that the SEC is repeatedly going beyond its jurisdiction, and Congress has the responsibility to ensure that it keeps the regulator in proper check, especially after the FACS and BlockFi fiasco. I laid out a few thoughts today in Fortune magazine on the need for congressional oversight of the SEC after the recent collapses of BlockFi and FTX. He asserted that the SEC is one of the major reasons why BlockFi got entangled with FSIN, consequently collapsed with the bankrupt crypto exchange. BlockFi had to look to FTX to support its financial stand in an attempt to meet the $100 in settlement demanded by the SEC following the charges brought on the crypto lender. Alderoty had made similar claims last November. Due to its resulting relationship with FTX, BlockFi filed for bankruptcy 2 weeks after X, citing its exposure to the exchange as the major trigger of its liquidity crisis. The crypto lender's collapse has resulted in losses in consumers' funds and over $1 owed to creditors, with a $30 imbalance yet to be paid to the SEC in the settlement. Alderodi mentioned that the SEC does not have the right to enact new laws for itself, and it does not possess as much power over the crypto industry as it claims to have. He then highlighted that it is Congress's duty to oversee the SEC and make sure the watchdog is kept in check, according to the Legislative Reorganization Act of 1946. The California-based lawyer pointed out the fact that the SEC's policies in the crypto scene have been frowned upon by several pundits and consumers within the space, asserting that the agency has more interest in exercising its power than adhering to sound policy. Ripple chief Brad Garlinghouse agreed with these claims, highlighting them on his Twitter handle. I know some may forget this fact from time to time, but Alderodi so eloquently said the SEC can only exercise the authority expressly granted to it by Congress. Check out more in Stu's op-ed below. Notably, U.S. lawmakers have begun questioning the SEC over its policies in the crypto industry following the FAC's collapse. Alderodi noted that he hopes Congress provides more clarity for the crypto industry this year so as to avoid more regulation. Enforcement moves from the SEC. This further mirrors Garlinghouse's previous remarks on the matter. Attorney John Deaton has asserted that there will be no settlement in the U.S. Securities and Exchange Commission case against Ripple till after Judge Ana Elisa Torres gives her summary judgment decision. The friend of the court in the over 2-year-long legal battle said this in a tweet yesterday as part of his predictions for 2023. 2020. 3 predictions. 1. The Thorpe case does not settle until after we get a decision from Judge. 2. In exchange, maybe more than one is sued for selling unregistered securities. 3. Investigation in the Spram meetings uncovers bad. 4. Gensler resigns before the U elaborating on his prediction. Deaton explains that both parties could enter an out-of-court settlement after the court ruling to stay a potential jury trial and potential jury trial and potential. Some people are confused about my prediction that the Ripple case doesn't settle until after Judge Torres renders a decision. A settlement could occur after, which would eliminate any potential jury trial and also eliminate any potential appeal. The prediction supports Deaton's previous stance where he argued that the case would make it to a court ruling as opposed to most XRP holders in a poll he conducted who believed the settlement was likely before summaring. At the time, the lawyer expressed that he no longer expected the SEC to seek a settlement to keep the Hinman documents private, according to Deaton. Despite recent efforts by the SEC and omnibus motions to keep the Hinman documents sealed, he believes that the SEC, which already agreed to a court order to hand them over to Ripple, is ready to risk the documents going. In addition, the crypto law founder believes that the SEC chair, Gary Gensler, is willing to gamble on an unfavorable SEC outcome. Furthermore, he added that the regulators had received a confidence boost with the win against El Bri and the facts collapsed. Notably, Deaton believes that the ruling in the SEC case against Ripple will be the only clarity the emerging markets get until the next bit. He said this in light of the negative sentiment toward crypto and Congress and the House's polarized nature that makes it less likely to pass many bills. Consequently, the crypto community is hoping for a court ruling in favor of the blockchain enterprise company as it sees a bloodbath in the event of a Ripple law. According to Fox Business's Charles Gasparino, notably the senior correspondent, believes that the SEC could force all crypto except Bitcoin to register his security. In July 2022, Deaton predicted that SEC is going to sue any U.S. exchange by the end of the year, which today came true after SEC charges Gemini for the sale of unregistered securities from July 20, 2022 on Fox Business. John Deaton known predicted what happened today. The SEC recently filed lawsuits against Genesis Trading and Gemini for allegedly engaging in the sale of unregistered securities. Gemini's Cameron Winklevoss has described the lawsuit as counterproductive as the crypto exchange is locked in a battle with Genesis to recover the funds of its earned program. Customers who have been unable to withdraw their assets on the crypto exchange for over 2 months. Notably, as part of its earned program, it loaned customer funds to Genesis to earn yield. However, Genesis, faced with a liquidity crunch, has paused operations. You can see the current price of XRP on your screens with a daily trading volume of $648,452,340. Used XRP has declined by 3.2 in the last 24 hours. Thank you for watching this video to the end. If you liked it, then don't forget to like and subscribe to the channel so as not to miss the release of new videos.